talking about common bylaw violations and how to handle them. Obviously, during these times, it's everything's digital now. We've got to kind of roll with technology, and so normally I do this presentation in person, and it's very interactive. And the whole goal is to get feedback immediately on the different topics. In this scenario tonight, what we'll do is we'll save the questions till the end. I'll try to get through the material that I want to cover and then open it up to everybody at the end for any questions or any thoughts or any situations you might be dealing with due to COVID-19 and just in general bylaw violations that you might be experiencing. So let's get started. Just a little bit about me. I'm a member here, a partner at Hirzel Law. You can look up my bio on our website, but for purposes of tonight, I'm actually currently the president of my own HOA in Novi. I was just reappointed or reselected as the president last night, in fact. So another lovely Zoom hearing to deal with this year. But I also lived in a condominium for 7 years, and so I've seen things on the co-owner side, with issues with a board of directors, and I've obviously been on the other side of it now as president of my own association. I see violations and have to address them. So what are we going to cover tonight? By far, the two issues of most importance that we deal with all the time that are bylaw violations deal with pets and leasing issues. I'd say if I had to put a number on it or percentage on it, 60 to 70% of the issues that we deal with pets and leasing. The remainder of the issues we'll cover tonight deal with marijuana and smoking, parking and towing issues, particularly with COVID-19 and everybody being at home pretty much. Seeing more and more of those lately. Hoarding and trash issues. Now that everybody is during the day pretty much at home with their neighbors, etc., we're seeing more and more of complaints. So-and-so is not moving their trash, or so-and-so, I believe, is hoarding, and it could be a fire hazard, things of that nature. The next thing we'll talk about is unauthorized modifications. Usually that's to the common elements. So we'll get into that a little bit, and then some cases. There's a case that we dealt with in this office about unauthorized modifications that we were successful at the trial court and in the Court of Appeals, and the Michigan Supreme Court just affirmed our win. So we'll talk about that a little bit. And the last thing is we'll talk about just other general common violations, noise being the prime one that we deal with right now. There's other issues with electronics such as Ring doorbells and security cameras, looking into other people's units, things of that nature. That will be at the end of the presentation. And then kind of tie in some of those concerns with COVID-19 as well. So let's get into pet restrictions or pet issues. So the first thing that we'll deal with is size and weight restrictions. The next thing that we're going to be tackling is emotional support animals. And then the last thing is the COVID-19 impact on pets, particularly with community living. So let's do the hypothetical. David, the dog lover, lives in a condominium that prohibits pets over 40 pounds. David decides that restriction is just preposterous. Tony buys a newborn dog that initially only weighed 15 pounds, but over time it got up to 100 pounds. And the association tells David, you have to get rid of your dog. It's too big. It exceeds our 40-pound weight limit. So, answer to yourselves. Normally I try to make this interactive, but we can't do that these days. So the question is, does it matter that when David bought the dog, it was only 15 pounds? And the question is David entitled to keep his dog? So we get this question a lot. There's a lot of restrictions out there in the bylaws that say you can't have a pet over 40 pounds, 35 pounds we see often. We typically see it, to be candid with you, on more the east side. Macomb County has a lot of these types of restrictions. Now, the answer to the question is, does it matter if it was 15 pounds and then 100 pounds? The answer is no. And the reason for it is there's a case from the Michigan Court of Appeals. It is unpublished, so it's not binding case law, and it's back from 1989. And the case held that you cannot restrict based on solely the weight of the dog. You have to have some other basis why the dog can't be there. The dog is aggressive. The dog is dangerous. The dog has bit someone. The dog, for example, if the dog breed is a prohibited breed, sometimes we'll see pit bulls restricted and not be permitted. The case from 1989 said you can't restrict based on weight, but you can restrict based on other factors. And so if you can demonstrate the dog is aggressive or it's a pit bull, and the documents prohibit pit bulls. Now, there is a caveat to this case. This case came out in 1989, but we've seen throughout the country, particularly there was a case out of Florida that dealt with a Fair Housing Act issue, and the court down there said you cannot restrict by breed. So we're in a little nebulous zone right now, whether you can prohibit dogs based on breed or not. We generally caution clients to not restrict by breed, but if it is a decision that they want to make based on the Bear Creek case, I think it's a defensible option. The problem is that there's a little bit of flux right now. So do you really want to be the test case to go up to the Court of Appeals or the Michigan Supreme Court to finally decide the issue? I don't think so. That's my personal opinion. But just be aware of this. If your documents have a pet restriction and you try to enforce it, somebody might throw this back at you and say you can't do that. And at least there's a colorable argument under that Bear Creek case that you can't restrict by size or weight. Which leads us to emotional support animals. So this has been, particularly with COVID-19, more and more people are at home, more and more people look at their restrictions, and if you have a restriction that says no dogs, more and more people are saying, well, I can just go online and I can do a search for emotional support animal, and I can pay a fee and get a certificate that says that I have the need for an emotional support animal, and therefore association, you have to let me have my emotional support animal. So let's do this hypothetical, and then I'm going to talk about a new case that just came down about a month ago. So Tanya subdivision has a covenant that prohibits pets. Tanya was assaulted as a teenager and was prescribed an emotional support animal, a dog in this case. Tanya requested an accommodation to keep her dog. The association advised Tanya that her dog violated the deed restrictions. The HOA filed a lawsuit to have Tanya remove her dog. Is Tanya entitled to a reasonable accommodation to keep her emotional support animal dog? So this is a hypothetical. A year ago when I gave this presentation, my answer was different. And the reason for that is there's a brand new case that came down that we're going to talk about in just a minute that has given more power to a board of directors and an association to investigate a claim by someone that they have an emotional support animal. So we'll actually we'll skip to that, and then we'll come back to my other slide. So this is the Riverbrook versus Fabode case. It came out September 17th, 2020. So we're talking about just over a month ago. And I'll give you the factual pattern in the court's holding. Very similar to the hypothetical that I just gave you. There was a gentleman lived in a mobile home with his sister. She was a tenant. He obtained a puppy that he claimed was a Labrador Retriever mix, but Riverbrook believed it was a pit bull mix, and that pit bull mix was prohibited. And they said, please remove the dog. Fabode then, not being undeterred, said, I'm going to provide you a document by USAR claiming that I have what's called a differential illness. And my differential illness requires you to give me a reasonable accommodation, and I get to keep my dog, even though you have a prohibition against, in this case, it was pit bull mixes. Now, USAR is United States Support Animals. It's a website you can go to, and you can pay $179.99, and they will give you, based on the website, they will give you a doctor's letter for an emotional support animal. It is what I would call a quid pro quo. You give me $180, all of a sudden now, boom, now you've got your letter claiming that you've got a differential illness, and therefore the association has to allow you to keep the dog. We saw this particularly last year, even before COVID, a huge spike in these types of requests and going online and pulling these types of documentation, these types of documents. Now, here's the interesting thing. There is no such thing as differential illness. Apparently, there's called differential diagnosis, and the Court of Appeals analyzed this and said, all that means is it's the distinguishing of a disease or condition from others presenting similar symptoms. Doesn't tell you anything. Doesn't tell you if it's based on depression, based on some type of trauma or history of trauma. It just says your symptoms are different than other people presenting similar symptoms. So Riverbrook said, that's not acceptable. That's not good enough. You need to take this dog out, otherwise we're going to evict you. And they ended up going to court and seeking to evict the brother, and ended up entering into a consent judgment. And the consent judgment was he can stay so long as he gets rid of the dog if the dog is not permitted. So then after that, he said, well, the dog's permitted because I've got this letter from the USAR, and so it says that I'm required, or I can keep my dog, and therefore you have to allow me to keep my dog. So the Riverbrook, undeterred, sent him a resident disability certification form, asked him to complete it, and just said, here are all the questions we have about, is this tied to an actual condition that you have, and is this emotional support animal fulfilling that condition and making your life easier and a better life based on your medical needs. And instead, the Fabode, being a little bit gregarious, I think, just did a generic response. Like, I need this to live my personal life, and I need this dog based on it. Nothing really concrete as to what his symptoms were or what his medical diagnosis is and how that translates to him needing a dog. Riverbrook responded, obviously, there's no credible proof of any disability, and therefore we deny your request. Of course, then there was a lawsuit, and the judge in the trial court, which was the district court, and then in the circuit court, said, well, we can't look behind the screen. We can't look and investigate medical decisions, and therefore we can't do any analysis of whether your medical condition is tied to you having an emotional support animal. The Michigan Court of Appeals, in a published decision a month ago, said, no, that's not acceptable. If you're going to have someone come in and testify as an expert that says you need to have an emotional support animal to allow you to live in your home, there is a gatekeeping function under Michigan Rule of Evidence 702 saying you actually do have to do some investigation, and you have to actually figure out, lower courts, you've got to figure out if this illness is actually tied to a reasonable request, a reasonable accommodation for you having the dog. You can't just go and pay a set fee and get a certificate and say, I've got this medical condition and you can't investigate it. The Michigan Court of Appeals said, nope, there is a gatekeeping function here and it should be investigated further. So it remanded it, which means it sent it back down to the trial court and said, trial court, you need to look at this more thoroughly and actually investigate the reasons for this alleged connection for the request for an emotional support animal. So this case is brand new, straight out of the Court of Appeals, and it's certainly something that I would anticipate further litigation on, either at the trial court level or going all the way up to the Michigan Supreme Court. So it's a case to pay attention to. But not only do we have cases now coming through the Court of Appeals dealing with emotional support animals, we also have a proposed law update. So in Michigan, we have a proposed House Bill 4910, and it was introduced about a year ago at this point. At the time, it had 13 co-sponsors. I think one of the co-sponsors has now dropped their name from the list. But it passed the House, 172 yeses, 59 noes, with 33 being excused and not voting. And so it's moving through the legislature, the Michigan legislature. What this bill does is it puts restrictions on emotional support animals and puts some teeth into actually investigating these claims, so that you can't just go and get a letter off of the internet and claiming that you have a disability, and then boom, all of a sudden you can initiate all of the restrictions regarding pets in your community association. So it's certainly something to follow. Right now, last it was referred in April to the Senate Committee on Regulatory Reform. That's where it is right now. Haven't seen any update on it in 6 months. So who knows if it's going to move through that committee and then move through the Michigan Senate and then get up to the governor's desk. But just something to be aware of is that there's potential new litigation, or excuse me, new legislation coming down the pipe for emotional support animals. And if you're on the board of directors and you're dealing with these emotional support animal requests, just know, because of this new case, this Riverbrook case, just be aware that you might have a little bit more you can do now than you could previously. There's now an argument you can do a little bit more investigating and trying to figure out whether this emotional support animal is appropriate or inappropriate. All right, getting into leasing. Now, when COVID hit, we saw a dramatic drop in what we call short-term rentals. A short-term rental, compared to a long-term rental, usually a short-term rental is going to be 30 days or less. Here's a bunch of, different areas. For example, the Fair Housing Act says 30 days or less. There was a House bill that said 28 days or less. South Haven says 29 days or less. Spring Lake, Michigan says 27 days or less. So realistically, it's kind of all over the map as to what constitutes a short-term rental. But I would just say 30 days or less is usually a pretty good demarcation line. And what we typically see is like a summer vacation home, a week-to-week basis. Those are typically what we refer to when we talk about short-term rentals. Just some examples of some of the websites that the popular ones out there are typically Airbnb and VRBO, but there's plenty out there. These are just some of them that are out there that people can use. Booking.com, Flipkey, HomeAway, Homestay, House Trip, Roomorama, TripAdvisor, the whole list. Why does that matter? Well, I've had board of directors say, hey, I checked Airbnb and VRBO, and I don't think this person's doing a short-term rental there, but I keep seeing people come in on a weekly basis, and it's new people cycling through. And, I'll ask them, have you looked at all these other websites? And then sure enough, you'll see, on one of the other websites, they're listed there. So just be aware of that if you're on the board of directors. It doesn't necessarily have to be Airbnb or VRBO. It could be one of the plethora of other websites out there that do short-term rentals. So let's get into Michigan case law. What's the status of short-term rentals in Michigan? Well, there was a published decision. It was 2-1, and it was back in 2017. And the majority opinion said that short-term rentals are commercial use. Even if the people operating out of the rental space are using it for a residential purpose, let's say they're coming up for a week for vacation, let's say they're coming up for a bachelor party or a bachelorette party, They're still living there, they're still eating there, they're still sleeping there. So realistically, you might think, oh, it's still residential in nature. The majority opinion said no. If you're going to be paying money to stay somewhere, that's going to be commercial use. And because the deed restrictions barred commercial use of real property, you are barred from having a short-term rental there. Now, there were two primary exceptions from the majority's opinion that I think are of note. I think that this is going to be the next area that is going to get explored with future cases. So the first possible exception is if the use of the property is incidental, i.e. if it's casual, infrequent, or unobstructive, then maybe that wouldn't constitute a violation of a commercial use restriction. Left the door open a little bit on that question, if it's an incidental use. The second issue that was raised was if the owner rented the property for a longer term. So basically the court majority opinion said, we're not going to even address long-term rentals, whether long-term rentals are a commercial use. That's a separate issue. We're only going to be dealing with short-term rentals. So another carve-out. Now the question becomes, what's considered a long-term rental? Historically, in our business, we think of a long-term rental as 6 months or a year or more. That's typically the demarcation line. But the majority opinion really didn't say, and just kind of left it up to the next case that comes down the pipeline to make that decision. Now, there was a dissent. It was a 2-to-1 opinion. And the dissent said, well, the renters use the property for eating, sleeping, other residential purposes, just like every else in the subdivision, so it should be just residential use. So right now, this is what we're operating under in Michigan. This eager opinion, even though it's 2-to-1, it is the basis upon which we deal with short-term rentals now. And with COVID-19, what we're seeing is actually a massive uptick in short-term rentals. And here's why. All the people who were going to take vacations overseas or fly out somewhere, nobody's flying right now, or at least a lot less people are flying right now. And so a lot of people this year decided, okay, I'm going to go rent a place up in northern Michigan or northern lower Michigan, and I'm going to do a week vacation because we can't go to Europe or we can't go wherever you're planning on going. So we're going to do a vacation, so let's rent a place. So interestingly enough, I thought, when COVID hit, I thought more and more people would just stop using short-term rentals. And after about 4 or 5 months, we saw a major uptick with people wanting to go and use short-term rentals. So it's still a hot topic issue. It's still a high priority for the development of Michigan case law, and it is something you should kind of pay attention to, given what we're going through right now. All right, again, this is just the breakdown of residential use versus commercial use, and how do you make that demarcation line or the determination as to what's residential use and what's commercial use. And so the factors again are, and we'll get into them, is there compensation? So is someone paying to live in a location for a period of time? That's going to lend itself to be more commercial use. What type of insurance does the owner have? There's 2 types of policies you can get, which is, a standard HO6 policy for most condominium co-owner unit owners. They're going to have a standard HO6 policy indicating that they live in the community and they're going to be living in the space. Now, there's a secondary policy you can get, and it's a non-owner occupied unit owner's policy. And so basically what that means is that you don't intend to be in that space. So, when looking at this determination of whether this is commercial use or residential use, you might get a little trigger just based on the insurance policy that the person has on the unit. So it's definitely something to take a look at. Also, the difference between the two policies are basically nothing except last I checked, Travelers Insurance charged a $150 surcharge if it was going to be a short-term rental. So basically the policy language doesn't really change between the two policies, but the cost does. So it is something to also it's a factor to determine whether are you doing a short-term rental here, or are you actually using it for your primary residence and you're going to occupy it. And then, another thing to consider is who actually owns the property. Is the property owned by a for-profit corporation? Is it, the owner on title, an LLC? Usually that can be a good indication that it's for short-term rental usage, as opposed to if the actual owner of the unit, let's say husband and wife, are on title. That's going to lend itself maybe a little bit more towards the residential use side, or at least it can be a factor, something to look into. Now, how do we attack or go after these types of bylaw violations for short-term rental? Oftentimes in your governing documents, there's going to be multiple areas within the governing documents that you can point to say, nope, you can't do this anymore. You can't do a short-term rental. We'll look at a residential use or a commercial use restriction. Sometimes you'll have a non-commercial use restriction that's even further than, no commercial activity may take place in this condominium, for example. You might have a leasing restriction. Usually that's contained in your restrictions section in your condominium bylaws. It's oftentimes Article 6 of your condominium bylaws, doesn't have to be. But you might have a leasing restriction that says that you can't have any rentals for less than 6 months or 12 months, etc. So definitely check that provision and see if that would apply. You might also have nuisance restrictions. Sometimes what you'll have happen is on a short-term rental, there's a party mentality. Bachelorette party comes up for a weekend, or a bachelor party comes up for a weekend, and they're terrorizing the place, noise very late. Going out to the water and causing a havoc, etc. So you might be able to use that restriction. Most documents have no illegal activity may take place within, let's say, the condominium or the homeowners association. You might have an unlawful activity restriction. We see that pretty frequently in that Article 6 restriction section. And then you might have rental caps. We're seeing that more and more with associations wanting to impose rental caps. So only 10%, 15%, 20% of the units can be rented out at any given time. So you might even have a rental cap that you're already exceeding the rental cap, and so new people trying to rent their units can't do so because you've already hit that rental cap. So those are the types of provisions you want to look for, the restrictions, and how we approach potentially attacking somebody who is using a short-term rental in violation of the governing documents. All right, quickly, let's just go through some creative arguments that we've seen or heard of regarding short-term rentals. Because everybody knows right now that short-term rentals are mostly restricted, if your governing documents restrict them, then the question becomes, can you get around those restrictions? And what arguments do we hear? So argument number one is, this is not my tenant, this is my licensee. So the definition of a licensee is a person who enters the premises not by invitation, but by permission of the owner. The licensee's presence is permitted by the possessor of the land, and it is not related to the purpose or interest of the possessor of the land. Key example about a licensee: you might have a farmland that during the hunting time you give a license to your buddy, in the sense of you tell him, hey, if you want to go hunt on my land, I'm going to let you. That's a licensee. A license can be revoked. But we've heard this argument, I don't have a tenant, I've got a licensee. I've given them my permission to be on my property for a period of time, and therefore they're not a tenant as your documents define tenant. They're a licensee instead. That argument does not fly, by the way, with most courts that we've seen thus far. Creative argument number two: this is not a short-term lease, this is a long-term lease. I had this very creative person tell me, I've got this lease agreement. It's a 12-month lease agreement because the governing document said you had to have a minimum of 12-month lease. But the first week was $1,000 for rent, and each subsequent week was $15,000. But the caveat was there was no penalty for terminating the lease after 1 week. So what we were seeing is every single week, the place would be booked. Every single week, the person would pay the $1,000. And then at the end of the week, they would terminate their 12-month lease and not have to pay the next $15,000. And so the argument was, this is not a short-term lease. I have a long-term lease, and I satisfy the requirements under your governing documents. Seeing this argument also does not fly. Creative argument number 3. This is not my tenant. This is only my roommate, my occupant, my guest. We're seeing this a lot more lately. Can't tell you how many times people have a home or a unit and they have a room that's available. So they will rent out a side room or a basement area and then claim that I don't have a tenant. They're just a roommate. They're a friend. They're a guest of mine. That type of argument, and therefore the question then becomes: are they paying some type of rent? Well, what happens if the person isn't paying rent? Let's say they're contributing to utilities, or they're contributing to food, or they have some arrangement where they're not physically paying rent to the person, but all right, I'll pick up all the bills for your utilities and your I'll buy the groceries every week, and so there's no actual formal rental agreement. It's just a relationship between either two friends or somebody who's just renting out a room. I've seen this come up. I've also seen this come up when trying to challenge somebody with this argument. They say, wait a minute, there's this couple who lives across the street. They're not married. They're non-familial. So, for example, if you have a same-sex couple in the next unit over, the argument is, wait a minute, you're discriminating against me because I'm not married to the person I'm with, and I'm not a family member of this person, but yet you allow somebody else to do it. And so sometimes you'll get that argument of, oh, this is harassment, this is selective enforcement, this is targeting, things of that nature. And so, just be aware of this as a potential argument. Most documents are going to have a provision that says any tenant or occupant. And so we've been able to utilize that language of occupant to say, nope, the rental restrictions even apply to occupants as well. You can't just try to rename somebody a roommate or a guest. An occupant is an occupant, and therefore they're covered by the restrictions on leasing. Creative argument number 4. This is not my tenant. This is an owner. So envision a unit is owned by a limited liability company. The corporation has 1,000 shares. The owner of the 1,000 shares sells 1 share to a short-term occupant, and the sales agreement has an automatic buyback provision of the 1 share for $1 within 5 days of termination of occupancy. So we've seen this argument try to be used and say, I don't have any tenants because I'm an owner, and there's no restriction in your documents about owners living there. And I have a share in this corporation, and therefore it makes me an owner, and therefore I can stay here. I haven't seen any case law in Michigan that has dealt with this. I've heard about this from other states, and so it wouldn't surprise me if eventually we see this argument try to be made. I don't think it would be successful, but without any case law on point, we're going to have to see how it shakes out. All right. Next bylaw violation we run into often is recreational marijuana. So Gary Ganja Gary owns a unit in the High Times condominium. Michigan has legalized recreational marijuana. Gary smokes pot every single day, and the hallway constantly smells, with the manager receiving numerous complaints. The bylaws prohibit a co-owner from smoking in the condominium or causing a nuisance, and the bylaws permit fines. The property manager in this case sends Gary a letter fining him $25 with an escalating scale under most acts. And Gary refuses to pay the fine, and he claims that his conduct is legal under state law, so you can't stop me. So the first question is, does the state law supersede the bylaws? And then the second question is the fine valid? So let's take the first issue. In Michigan, one might think, okay, well, if you want to smoke marijuana, you can smoke marijuana, no big deal. The association can't get involved. There is a discrepancy between our office and other offices who practice in this area. We have always taken the position that federal law still makes marijuana illegal, period. And if you do something illegal within the condominium, if federal law prohibits that activity, because marijuana is still considered a Schedule I narcotic, then in that circumstance, you're still doing something illegal, and that's still a bylaw violation. We have heard arguments from other law firms that practice in this area that say, well, if Michigan allows it, then we think that that's okay. From a legal perspective, we don't believe that that's the case, and we think it's more defensible to say if it's still illegal at the federal level, then it's still illegal, and therefore you could go after that person and with a bylaw violation and tell them they need to stop, and or you're going to pursue either a fining, an escalating fine, or further enforcement action. So now the question is, they assessed him a fine of $25, and the next fine is $50, and the next fine is going to be $75. Is that fine valid? Well, if you read the hypothetical, the fine was levied against him without notice to him that a fine would be levied, and a hearing. And I want to make clear for everybody on this webinar, the Michigan Condominium Act specifically requires, if you're going to levy a fine under MCL 559.206C, that you have to provide that notice and that hearing before the fine is levied. Oftentimes what we see is property manager sees a violation, they send the first letter. Oftentimes that first violation is $0. It says stop doing this. The next violation comes out, says $25, then $50, etc. But if you haven't given that person an opportunity to meet with the board of directors at the next board of directors meeting, you haven't given them a hearing on the issue, under that statute, any of those fines cannot be properly assessed. And so you want to be very careful if you're going to do a fining scheme that you do it in such a way that it complies with the Michigan Condominium Act. So just think about that next time you're dealing with somebody, or if you're a property manager, think about that procedure that needs to take place to make sure that that fine is valid. The next hypothetical deals with the Fair Housing Act and medical marijuana. So Devin, Evan, and Shmevin sit on the board of the Leafy Greens Condominium Association. Smokey is a stressed co-owner who suffers from anxiety. The condominium documents ban smoking. Smokey has a medical marijuana card. Smokey requests a reasonable accommodation under the Fair Housing Act to smoke marijuana in his unit. Smokey has a note from his doctor that marijuana will help his anxiety. A debate ensues on the board of directors. Devin says marijuana is an illegal drug. Says denied. Evan says medical marijuana is legal in Michigan. He's got a medical marijuana card, so I'm going to grant. And then Shmevin comes along and says, well, the doctor's note looks legit to me. I want to be a good neighbor. Maybe we should call the police and see if this is legal. So in this circumstance, what should the board do? You've got a situation where one is saying yes, one is saying no, and one is saying, I don't know, maybe we should call the police. In this circumstance, the argument about a reasonable accommodation under the Fair Housing Act to smoke marijuana, again, Devin in this circumstance is correct. Marijuana is an illegal drug. And so even if you have a medical marijuana card, the argument is it's still an illegal activity at the federal level, and therefore you should not be permitting it in your association. Does it matter then if it's medical marijuana or recreational marijuana? Well, I just answered that. The answer is no, at least in our opinion, based on federal law as it currently exists. Now, could that change in the future? Absolutely. Are we anticipating that it may? Yes, we are, but until that happens, this is a scheme that we're dealing with, and this is how, when a board comes to us with recommendations about what to do or questions about what to do with marijuana, this is our position, and we think it's the most legally defensible position given the status of the law at this time. All right, what about growing marijuana? So Cheap Chuck becomes emotionally distraught and simply can't handle being on the Walla Walla condominium board anymore. He resigns and starts a recreational marijuana business. The condominium bylaws prohibit illegal activity. Michigan just legalized recreational marijuana. And Chuck sets up some grow lights in his basement. But to save money, he plugs his grow lights into the electrical outlet inside his unit, or on the outside of his unit, and the association's electric bill increases $10,000 for the following month. So the first question is, can Chuck grow the marijuana in his unit? And the answer to that question is, it is a commercial activity. He is growing it for a purpose, so you could restrict it on that basis, but also it's still an illegal substance, and so no, you can't grow it there. Plus, I believe there's a regulatory scheme as to where and how many plants that you can grow. If you have a medical marijuana card. So that's another factor in this, but it doesn't really matter because you can't grow marijuana in your unit. Can the association recover that $10,000? Most often we see in the governing documents, we see a provision that says that a co-owner cannot commit waste. And so that's the question. I've seen this not just with the usage of electricity, but I've had a couple cases where somebody has a drip in their unit, a faucet, a tub, and it just drips, and then all of a sudden the association gets a bill for $5,000, $10,000, that water bill that they weren't expecting, and they say, wait a minute, there's a huge uptick, and building 14 now has this massive water bill. What is going on? And we've been successful in arguing that if you're a unit co-owner, or excuse me, a unit co-owner, yeah, and you just allow the water to just keep going, and the association is responsible in your association for water, that is considered waste, and they can charge it back to your unit. So you got to look at your governing documents. You got to also look at, what are the costs involved and what are the increases, and does it make sense to go after that additional cost that's been incurred by the association, whether it be electricity or water. All right, next bylaw violation that we see often is parking and towing, and we're actually seeing a little uptick in this because most people now have been home for 6 months and not driving to work every day. So we're seeing more and more vehicles that are inoperable, or we're seeing more and more vehicles that are unstickered. And so, they failed to get the new sticker for the next year, from the state of Michigan. And so therefore you've got out-of-date plates and or you've got an inoperable vehicle. So give the hypothetical. So Limited Space Association has a problem with parking. Co-owners are assigned parking spaces under the condominium documents. The association's governing documents say towing is permitted, but the association does not have a sign regarding the towing of vehicles. Guest Gary parks in the reserved spot, and the association is furious and orders Towing Tony to remove the vehicle. Does the association have the right to sticker and tow the vehicle? The answer is no. If you look at the hypothetical, it says that there is no sign regarding the towing of vehicles in the condominium. So what statute are we dealing with? We're dealing with MCL 257.252K. And one of the requirements, if you look into section D, is you have to have a notice, and it's got to be prominent, and it has to be no less than 4 feet from the ground, and it's got to be continuously maintained on the property, not less than 24 hours before a vehicle is towed or removed. So basically what that means is if you don't have a sign in the front of your condominium or in the sign of your private subdivision, if you're going to tow from private property, these are the requirements that the statute demands of you. You're going to have a sign. The lettering has to be no less than 2 inches. It has to be displayed at a prominent place, usually at the points of entrance. There's requirements as to, before you just decide I'm going to sticker and tow a vehicle, you got to make sure that you're covered here. So we do see bylaw violations all the time, particularly now with parking issues and towing issues. But if you're going to tow, if you're going to take that step, just make sure you're in compliance with the statute.
Are you taking questions?
All right, we're about 45 minutes in. I'm going to try to go for about another 15, 20 minutes, and then I'm going to open up for questions from the group. So the next thing we'll talk about is hoarding. Now, this is something that we're seeing more and more, and the reason we're seeing it more and more is because so many people are at home, they see their neighbors more often, and if a neighbor opens their door and then all of a sudden you can look in their unit, we're seeing more and more of an uptick in hoarding situations. So the hypothetical is Harriet the hoarder lives in clean living condominium. The board of directors becomes aware that her unit is stacked with newspapers from the floor to the ceiling. However, she did clear a path from the front door all the way to the back door. So the question is, what should the board do? And the second question is, does it matter if Harriet has a mental health disorder? So the first question, what should the board do in this circumstance? Well, first and foremost, you might want to perform a wellness check on the individual. And secondarily, what you might want to do is, in order to effectuate that wellness check, is to call your fire department. Now, why would you do that? Well, in this circumstance, her unit is stacked with newspapers from floor to ceiling. And if she's neighboring, multiple units in a condominium, adjacent units, there's a serious potential fire hazard there. And so the question will be, do you want to talk to the fire department and get in there and just see, okay, is this a fire hazard? Number one. And number two, does she really have access from the front door all the way to the back door, or another point of ingress and egress from her unit? So you might, it might be worthwhile to reach out to the fire department to do that wellness check, to get in there, because it may well be that they determine, yeah, this is a very dangerous situation, and if there's a match or a fire, that this place is going to go up very quickly because of all the newspapers, and particularly old newspapers usually dry out. So, it is something that you're going to want to have the fire department get involved in. I've also had clients call me as the attorney to say, hey, I need you to address this. Can you write a letter to the person so we can gain access to the unit and then do our own investigation and then determine after that what to do next. Because sometimes what you'll do is the person will clear out their unit, and it may last for a month, it may last for years, but you can get in there and at least check it out. And sometimes they just need a little bit of motivation to clean up their place, and so it's not dangerous to other co-owners within the condominium. Now the question is, does it matter if Harriet has a mental health disorder? So there's some literature out there that says that hoarding may be a mental health disorder. So this is something I think we're going to continue to monitor and look at and see if there's anything that comes down legislatively or case law. Do you have to be careful if the person has a mental disorder you have to be careful about trying to get them not to be a hoarder or potentially cause massive damage to the condominium through a fire, or sometimes you'll see cockroaches throughout a unit, things of that nature, and then the cockroaches go up through the air conditioning units, etc., or the ducts, and then they go to the next unit, and that's sometimes how the first trigger that you'll know that there's a problem in the next door neighbor's unit, based on the existence of some type of bug or infestation. But I do want to just note this for those board members who are dealing with this issue. There may be an argument that the person has a mental health disorder and they can't control their actions, and then the question becomes, is that a defense for being a hoarder? At this point, we haven't seen anything that says that is the case. But as the literature grows in this area, it's an interesting thing to track and watch and see if there's an argument to be made later on that it's a defense to a hoarding situation. All right, let's get into unauthorized modifications. We're seeing an uptick of these as well due to COVID-19. When everybody was at home instead of going to work, we ended up seeing a lot more projects being done around units, on the outside of units, beautification efforts, people actually doing more work on the outside. So then the question becomes, what's appropriate, and then what's considered an unauthorized modification. So I'll give you this hypothetical. Hot Tubbing Harry lives in the Steamy Springs Condominium Association. The bylaws require board permission to alter the elements. Harry installs a hot tub on his limited common element deck, and that is only for his use. He hooks up the electricity to a wall on the inside of his unit with a dedicated 220-volt circuit. Harry fills the hot tub with a hose, and he does not connect to the association's water supply. The bylaws are silent on whether hot tubs are allowed. So the question is, if the association sues Harry to remove the hot tub, does he get to keep it? Now, there's a couple things here that are important. This is an actual case. This happened back actually in 2001. For those interested, it's the Hunters Point Condominium Association case. This is the Court of Appeals decided that because there was a dedicated 220-volt circuit that had to be installed to power the hot tub, under the Condominium Association documents, the installation of the hot tub was a change in the common element, and therefore that could reasonably be prohibited by the board of directors. And so in this circumstance, you don't get to keep your hot tub. Sorry, Harry, it's got to go. All right, what about unauthorized modifications when it comes to disabilities? Now, the Condominium Act has an entire provision that deals with this, and it's MCL 559.147A. So I'm going to use this hypothetical and then talk about how unauthorized modifications apply with disabilities. So Builder Bob is in a wheelchair, and he needs a wheelchair ramp. The condominium bylaws do not permit modifications to the common elements without board approval. It's kind of similar to the previous hypothetical. Bob submits a plan for a ramp with 25 lights on it that shine into other people's units. The board meets quarterly and does not meet for 3 months to consider this request. They just had a meeting, and so they'll just wait 3 months to respond to Builder Bob. Bob says, okay, I'm tired of this. I'm tired of waiting. It's been 3 months. I'm going to build the ramp without approval because I'm tired of waiting. The board sends him a letter and says, you have to remove it immediately. Bob refuses, and the association sues. So the question then becomes, who wins under the Condominium Act? Well, the interesting thing here is, for disabilities, there is a requirement under the statute that if the association does not approve or deny the plans and specifications within a 60-day period of time, the co-owner can make the proposed improvement or modification without the approval of the association of co-owners. So in our hypothetical, if you'll remember, there was he waited 3 months. The board waited 3 months to respond to his request. Sorry, that's 90 days. That's longer than the 60 days. Bob gets to do the modification whether you like it or not. So obviously, in circumstances like this, if you get a modification request, first look to your governing documents first and see if there's any timelines in your governing documents. For example, for my own association, we have to respond within 10 days or within 30 days, depending on what the issue is. And so there's a very tight timeline in order to respond. But not only in your governing documents, the statute also has a 60-day period of time with regard to disabilities. So you definitely want to look at not only your governing documents, but if you get a modification request and it's for a disability, immediately contact your attorney and just make sure you're doing everything appropriately and within time. All right. So what else are we seeing? What other common bylaw violations do we deal with? And candidly, what other issues do we see during COVID-19? We are seeing a massive uptick in noise violations. With everybody living and working from home, a lot of people are on Zoom all day. The next door neighbor might have a barking dog, might have kids running around, etc. I'd say probably in the past month we've had probably 5 to 10 new cases just dealing with noise alone. Complaints about noise, how do we handle it? Can the co-owner contact the association and they do something about it? Does the property manager have a responsibility about noise? Or is this a dispute between two neighbors and the two neighbors need to figure it out? And if one thinks that the noise is too loud, should one co-owner sue the other co-owner and keep the association out of it? So we do see these often now. Noise violations just seem to be a new growing area for us to deal with. The other thing that we deal with often now too is with pets, we're seeing a lot more dog bites. For whatever reason, we've probably got 3 or 4 new cases in just in the past 2-3 months. And I've got a pending motion for summary disposition on a dog bite. 2 neighbors next door to each other, everybody's at home, and pets being try to let pets out and enjoy the common elements or the backyard, and all of a sudden there's a dog bite, and now the association gets involved to get the dog out of there. Signs and lawn ornaments. So right now, obviously, we've got a political debate this evening, but we've got an election on November 3rd coming up in just a few weeks. And so we're seeing a lot more political signs, and then questions regarding, well, our documents prohibit signs. Can you prohibit political signs? There was a proposed statute amendment a couple years back that didn't actually go through to allow for political signs in condominiums that have prohibitions on having signs put up. Also, you might have an argument that there's a waiver. The association has prohibited signs, but they've always allowed political signs. So right now we see those types of bylaw violations come up, and then the question is, can I force my neighbor to take down his Trump sign or his Biden sign? I don't like that sign, so I want them to force them to take it down. So getting a lot more of those questions. I think those questions, hopefully will be over in just a couple weeks, and so it's not going to be as big of an issue. But every 2 to 4 years, you're going to see these issues come up, and then the question is, do your documents allow for political signs or not? Is having a sign a bylaw violation? Also, we've not seen this as much, but religious symbols. Sometimes you'll have a nativity scene, an angel statue, things of that nature. I've got in my own association, there's one of my neighbors has a massive angel statue, and then the question becomes, if your governing documents prohibit statues, does some type of religious symbol, does that count? Does that count as a statue, or are you just exercising your First Amendment right to have some type of angel up or nativity scene or mezuzah? So Another thing to look out for, if you've got this issue and you've got a complaint, there's a local to here. There was a fight over a nativity scene, and an association went after somebody for putting up a nativity scene, and it was all over Fox News, and it was all over like right-wing media talking about this issue, and so it's been a hot topic, and so just something to be aware of. And definitely, if you've got a question about it or an issue, contact your attorney, and they'll walk you through, okay, what do the documents say? Is it permitted or not permitted? And give you, a sound legal opinion as to what to do about the situation. Another bylaw violation we see is privacy concerns. So I've got a Ring doorbell at my own house, security cameras, things of that nature. It's one thing if the security cameras are aimed at, let's say, the entranceways to a unit. I had a case where somebody decided to put up 8 security cameras, 2 at each corner of their unit, and they looked outward, and they could record both sound and video. And what ended up triggering us to know that this could be an issue is the person posted pictures from their security camera looking into another person's unit on Facebook. And so then the question becomes, can you have security cameras? And if so, do you have restrictions that limit where those security cameras can look? For example, in the next door unit, they had 2 young children that sometimes ran around the house naked. And if you've got a security camera that picks up, movement and then records it, now do you have a potential situation where they might have some inappropriate material now stored on their security camera? So I anticipate that issue is only going to increase as more and more people have security cameras, Ring doorbells, things of that nature. And so it's a growing area, and it may well be a bylaw violation to be looking into other people's units and either taking pictures or video within other people's units. Other issues that we're dealing with now is access to units to inspect the common elements. Typically under most documents, the association is going to have the right to inspect your unit or the common elements inside your unit. And so we're having more and more people with COVID say, you're not allowed into my unit, period. I'm not allowing you in. I don't know if you have COVID. You can't come into my unit to check things. So, under most documents, the association has the right to come in if they request it appropriately. And so in those circumstances, that would be a bylaw violation if they denied access to the unit. But you would want to get your attorney involved and talk to them about it, and then do it in such a way to make sure that you're complying with your request obligations under the governing documents to allow access to check a common element. And if that still doesn't happen, the next step would be to file a lawsuit and have a judge order access to the unit, which you would still be able to argue it's a bylaw violation for denying access in the first place. And the reason that matters is if the association is successful, under most governing documents, you may be able to argue you're entitled to your attorney fees and costs. So something to think about in that process. Drones, we're seeing not as much as I thought we would this year. Last year, we had a couple issues with drones over pools, taking pictures of people in the pool, things of that nature. I think drones are going to be something to think about moving forward. Property managers using drones to go and fly around and find bylaw violations, things of that nature. We're seeing a couple property management companies that have dedicated drones now so that they can quickly go around the entire sub and find out problematic areas or if your documents have restrictions on sheds or something like that, all of a sudden you've got a drone that goes over and finds all the sheds. So it is something to just be aware of, and that can cause bylaw violations or find bylaw violations. All right, another one that's kind of a hot topic and something that we're working into our governing documents now more and more is social media issues. For example, we call them gripe websites. So like, for example, happyacresiscorrupt.com. If you've got a happyacres.com, where the board of directors posts things, and then you've got a separate gripe website. those types of complaints. The Nextdoor app is another way that a lot of, or Facebook can be, particularly Facebook groups, can be ways that people are complaining or dealing with posting things, sometimes even defamatory things about other co-owners or about the board of directors or about the property manager. We're seeing more and more of the social media usage. But there's a difference between a gripe website and then a false website. So I'll give you an example. You might have happyacres.com as the association's website, and then somebody creates the website happyacreshoa.com, and it could look the same. It could have all the same information, and then on the board of directors page, it can be, this board of directors is not doing its job, and we are the next 5 people that want to be on the board of directors. And so, there's a difference between a gripe website and a false website, but even the false websites can have portions of it that have a gripe fest, so to speak. One of the biggest cases that came out, it was based out of Florida, and we see Florida tends to be one of the leading areas of the law when it comes to community association law. And so we see these types of cases come out where one neighbor doesn't like the board or doesn't like what's going on, and so they start creating these websites or creating false websites to make the board look bad when they're going into an election to try to replace the board of directors. And so that can, depending on what your governing documents say, that could be a bylaw violation if you have a restriction on certain social media platforms or issues, and something that I definitely think is only going to grow in the future. I think we're going to be seeing more and more cases that deal with these types of social media problems. All right, 3 slides left. So what about pre-existing common element modifications? So Mary buys a unit in the Fox Point condominium in 2013. The bylaws do not permit any modifications to the exterior of a unit without approval from the association. The prior owner, before Mary moved in, painted the front door, changed the style of the address number, and changed the style of the lock before they sold the unit. Then Mary came in and she replaced her door handle without approval in 2013. The association does not discover the violations until 2 years later in 2015. The association files a lawsuit seeking an injunction requiring Mary to remedy these issues based on the specifications set forth in the association's rules. So in this circumstance, they passed rules and regulations that required everybody to have a similar door, same color paint, same color, consistency throughout the entire condominium. Is Mary responsible for the violations of the prior owner? And has the association waived its right to enforce the bylaws by waiting too long to take action? Well, this happens to be a case our office handled. We were successful at the trial court and successful in the Court of Appeals, and the Supreme Court rejected the case, which means we won this one. This is one that I was talking about earlier in this presentation. And the answer is Mary responsible for the prior violations? The answer that the Court of Appeals and the trial court said is yes, you are responsible for the prior violations. So then the question is, has the association waived its right to enforce the bylaws by waiting too long because they didn't discover it for 2 years? One of the defenses Mary made was, wait a minute, it's been years. You've had years to come after me and you didn't do anything about it. You waited too long. And the trial court and the Court of Appeals said, nope, when they discovered it, they figured it out. They notified you to correct the issues. They give you every opportunity to try to correct those issues. You didn't want to do that. And therefore, the association is successful. And you are responsible not only for your own violation that you did, but also prior violations of the prior owners, because they made modifications before she moved in. And too bad, so sad. You should have changed the paint, changed the numbering of the address, and changed your front door handle. All right, last slide here is just what options do you have if you have a bylaw issue or bylaw violation. So you've got enforcement options. You've got the ability to fine under most documents. Obviously, you need that notice and that hearing in order to levy that fine. You can lien a unit. You can file a lawsuit for money damages. You can seek injunctive relief, which basically is just saying you're asking the court to compel someone to do something or prohibit them from doing something. Most documents allow for the recovery of attorney fees if there's a bylaw violation and the association is successful. Make sure that your documents have that provision in it. It's really helpful for enforcement and consistency throughout your condominium. And the question is, does that cover, does it cover pre-litigation costs? What happens if you retain an attorney to investigate the issue, write a demand letter, etc.? You seek those costs against the unit as well, not just once the attorney files a lawsuit. Because by that point in time, usually the attorney has had to investigate the whole thing, draft the demand letter, interacted a little bit, usually with the co-owner in some capacity. And then if it goes to the next step of litigation, the question is, can the association recover those attorney fees and costs expended trying to get the person to comply without filing a lawsuit? So you're going to want to make sure that your governing documents have that provision in it so that those fees can be assessed to the unit. So that the association's not out the pre-litigation attorney fees and costs. And then obviously, the last enforcement option is do a bylaw enforcement or collection policy and be consistent with your implementation of a bylaw enforcement or collection policy to avoid any selective enforcement claim or harassment claim or things of that nature. So that's going to wrap it up for me tonight. I'm now going to open it up to everybody. If you guys have any questions, I'll try to do them one at a time and go from there.
You're muted.
Thanks, everybody.
Okay, we're not going to ask, are we?
All right. Does anybody have any questions?
Yeah, this is Noel from Traverse City.
Hi.
Hi. A couple of questions. I'm a association member and past president. So these questions are as a resident, but it relates to board activity. What is the protocol if boards do not conform with enforcement of bylaw requirements generally?
So the question was, what happens if a board doesn't comply with its fiduciary obligations? I'll use that term.
Yeah, that's good. I use it.
Regarding the governing documents. Well, it's interesting. Most documents, and there's been some case law on this recently, most documents have what's called an anti-waiver provision. And what that means is if the association hasn't enforced stuff in the past, that doesn't mean that they can't enforce restrictions in the future. So the first question is, do you have a provision dealing with, an anti-waiver provision? The next question, more to your point about what happens if the board is not enforcing its fiduciary obligations, the question that I would ask is, have they sought the advice of an attorney, or if it's a financial issue, an accountant, things of that nature? And the reason why that matters is because there's called the business judgment rule. So if you rely on the advice of an attorney and an attorney says, well, there's an argument here that you don't have to allow this, or you don't have to enforce this restriction for whatever basis, then you have a defense called the business judgment rule, which is you relied on the reasonable advice of a professional in the situation. Now, what is a board's obligation? I've already given the answer. You have a fiduciary obligation to enforce the documents. So the question then is, are they are they exercising their fiduciary obligation? If they're not, then what I would do is I would notify them and say, hey, this is why you're not enforcing your fiduciary obligations. Here's the problem that you're dealing with. Therefore, you need to do X, Y, Z, and seek to compel them to do it that way. If that doesn't work, the democratic solution is always run for the board of directors and take over the board, and then now you're on the board and you can enforce those restrictions as they should be. But I try to caution people when I say these boards they're volunteer positions. They're usually unpaid. Most often they're doing the best that they can. So it really depends on how egregious the actions are, and so oftentimes what I tell people is talk to your attorney first, get a sense from the attorney, is this something that they do have a fiduciary obligation to do, or do they have some type of out or ability to say, nope, we can waive this restriction, or let's say they are allowing all kinds of sheds in the community, and the documents say no sheds. But the Architectural Control Committee has the ability to give people the ability to put in sheds. If the committee has powers to take action, that might be one way to get around any restrictions. So depending on what the issue is, I would want to know more information and look at governing documents to make a determination whether they're acting appropriately or inappropriately.
Let me pursue that just a little. You are our attorney. Your firm is our attorney. And the board has been counseled on the fiduciary responsibility to follow the documents. But there seems to be a culture on the board that says, don't worry, be happy, let's all be nice to neighbors together, right? So there's a do not disturb attitude in the board. So, running for the board or whatever, yeah, that does it or whatever. But in the meantime, hypothetically, we don't allow parking in the driveways if you've got space in the garage. And you're supposed to provide space in the garage, not use it for storage. People are using the garage for storage and parking their hijacked trucks in the driveways. And one of them has a vote for the Proud Boys sign on the back of their truck in the driveway. And the board says, well, we'll see what we can do. But months go by and nothing happens. What do? Live with it?
In that circumstance, if this is something where we represent the association, we would expect normally that the board would reach out to us, and then there would be a discussion and a recommendation made. But I'm not familiar with your association, or at least I don't think I'm the attorney that deals with this association. So
that's true.
So candidly, I don't know enough about the situation to weigh either way. So the typical process though is that if it is something that requires a legal interpretation, then we'd expect the board to reach out to us. But that being said, that decision whether to reach out to the attorney or not is a decision that the board makes.
But what about as a homeowner?
I can't really comment any further than that.
Right. Thank you.
Oh, somebody's asking. I can't see it now. All right, I can't. Can you type out your question, because I'm not hearing you, even though you're not muted.
Hello.
Oh, there we go.
Can we ask a question now?
Yeah, go for it.
Go for it. Go for it. Okay. We're a small condominium complex. We are self-managed and have been for 14 years, and things have gone well. However, several years ago, the association voted for the board members to be compensated. It's a relatively small amount of money that we get on a monthly basis to do all of the work that an association, a condominium manager does. What in the world are could be the possible ramifications of us being compensated?
All right, so the good old compensation question. So I got some good news and bad news for you. So the Nonprofit Corporation Act gives massive, massive protections for individuals who are uncompensated, volunteer directors, officers, etc. Okay?
You can't get people to volunteer.
Yep, totally. Definitely understand that. I'm president of my own association. I wish I would be able to pay me. I definitely understand that. It's a give and take. You're gonna give up a lot of those protections that you have under the Nonprofit Corporation Act if you have compensation. There is a distinction though, and I need to be very clear on this. There's a distinction between compensation and reimbursement of expenses. Reimbursement of expenses is not compensation. So if you're printing out a whole bunch of stuff and sending out letters and having to go to Office Depot and get all these supplies and things of that nature, reimbursements totally fine.
We can just call it reimbursement for our time.
I see. This is where you're getting into a very big gray zone. Our recommendation often is don't compensate unless you absolutely have to. Most documents say that the board's not going to be compensated. Some documents have a restriction that says that they can be compensated if 60% of the membership votes to approve compensation. So you might have.
We did get that at an annual meeting.
Okay.
And we have it written. I mean, it's in the minutes of the meeting, and it's there.
Okay. Well,
so in the event of a lawsuit of any type against us, then we are covered because we did get the approval of the association.
Well, I don't want to go that far because it depends on what you're doing. If you're the treasurer and you still steal $60,000 from the account, you can't say, "Oh, well, everybody approved and I just,
Well, that's not going to happen. We're covered as far as theft and things like that with our insurance. We've made sure of that.
Okay.
We just do the everyday thing, the walking, the doing, the contracting, seeing that everything that a management company robs people for doing, just being honest, and we do all of that work for a very meager amount of money.
Then the question I would ask you, Linda, is it worth it to get compensated and then expose yourself to the risk that you might be running because
that's what we want to know is the risks.
Yep. This is a question I get often. The answer is it's a risk reward analysis. The risk is you lose the protections under the statute by doing the compensation. So is it worth it to you, particularly if it's a meager amount of money? Is it worth it to you to lose those protections? I'll just be candid with you. If I lost those protections for myself in my own personal capacity, I wouldn't be the president of my association. I just absolutely wouldn't do it. I want those protections, and I want that protection.
Okay, we have been under self-management for over about 16 years. We've kept a management company out of this complex for 16 years. And during that time, we have been able to accumulate money because we haven't had to pay a management company. And we have done our best all through these years, and there's been absolutely no problem. But trying to get someone to step up and even be on the board with a meager amount monthly. That's all we practically have to beg people.
Yep.
They don't want to be bothered with people.
I
So
live
what's
in
the answer to that?
I live in an association with 189 houses. We just had our annual meeting, and getting 21 people on, which was our quorum requirement, was a monumental task where I had to go
I
out and try
can
to.
imagine.
Yep. So I can't help apathy. There's nothing I can do about apathy. If people don't want to participate, they used to call condo living, by the way, carefree living. Like you moved in and everything on the outside taken care of for you, right?
Yeah.
I definitely understand the issue that you're dealing with. All I would tell you is, based on your initial question, if it was my choice, I would not get the compensation, but that's just me.
If we don't do this, then a management company comes in here, because it'll have to happen, and there'll be no way on earth that we can survive financially. And that is the reason that we do it. And we're called the three old ladies. I'll just be honest with you. And these three old ladies take care of jobs that men should step up and do, but they don't have the shoes to step up and do it.
I am not stepping into that at all.
I
Put it
don't
this way.
mind stepping into it because it's true. It's true. The
I'll
men
just say
around
this.
here sit on their patios while they see us out here working. You know,
All right, Linda.
they'll smile and say, well, hello, how are you today? And I just want to punch them. I'll just be honest with you. But anyway, you've halfway answered the question, and we appreciate it.
All right. Thanks,
Hey, Joe,
Linda.
can I toss you a couple of quick questions?
Yeah, sure.
Who are you
Go ahead.
talking to?
Okay. So, Joe, you mentioned business judgment rule after you sought advice from an attorney. When we decided to open our pool and tennis courts, we attended a seminar very similar to this one, which gave us some, ideas of what was proper under Michigan law. So, we put a waiver out there and, put restrictions on the pool using what we believe was the business judgment rule. We didn't contact an attorney or anything like that. I think we were well within our right to do that. Would you agree?
Well, I'm going to tell you that it has to be legal advice from a professional if you're talking about an attorney. So going to a seminar like this, if you're not getting legal advice, if this is just a generic discussion, I don't know that would be covered. I'm not saying it's not covered, but the business judgment rule really applies to, you've got a tax issue, you're going to an accountant, getting an opinion on it. You're going to an attorney, you're getting an opinion on it. And so, things of this nature, they're educational in nature. I think an argument could be made, but I'm not going to pigeonhole myself right now in saying that a seminar like this, whether our office or some other office, I don't know that would satisfy the business judgment rule.
Would consulting the local health department cover that?
I think the answer is they're all good arguments. If you say to a judge, these are all the steps I took to exercise my fiduciary duty, and I went to the health department, and I went to the seminar that was provided, and things of that nature. I think that would be part of the defense. I think there are arguments that you could make. Let's put it that way.
Okay. And another question, I'll try to be brief. You mentioned something about rental caps, or a certain percentage, and also selective enforcement. We've got a situation where the original developer back in 1985 had a tough time selling his units that he built. And in order to sell them, he went to the prospective buyer and said, hey, what do you want to see? Do you want to see your unit being able to be rented, or do you want to say it's never going to be rented? And based upon what the purchaser said, he wrote in a rental restriction of 30 days or more, or basically by the hour, believe it or not. So, some units have no restrictions. Other units have 30 days or more. Ironically, the units with the common entrances right, where one entrance meets the 4 units, have the least restrictions, and the units that have their own individual unit entrances with a courtyard, those have the most restrictions. It's counterintuitive. We're trying to resolve this. Is what we have legitimate today, or in your opinion?
Without actually looking at your documents, I have no clue. I will tell you this right now. It's very odd to have some units have certain restrictions and then other units have other restrictions. I've seen it maybe once or twice doing this for approximately 15 years as I have. I would definitely have your attorney, and if it's our office, it's usually Matt or Kaylee that would be looking into that for you. I would definitely have an attorney look at it and see if those restrictions are viable or not viable. I'm just going to be candid with you. I don't know the answer, and my guess is that I would need to actually look at the restrictions as they're drafted before I would be able to even offer an opinion on it.
Hey, makes sense. Thank you. Good seminar.
Thanks.
You
Hey,
spoke
Joe.
earlier about when one owner has a complaint against another owner, and you said sometimes there are situations where you would want the owners to talk to each other and settle it, and sometimes the condominium would have a responsibility to step in. Could you talk about the distinction between those two and when the association should get involved?
Yeah. So it's a hard call. It's a judgment call, and it's often made by the attorney for the association. I see this question come up all the time where there's problems between co-owners, and then the question is it sufficient that it is an issue that impacts the entire association or a majority of the owners or a group of the owners, or is this a situation that is just a fight between two neighbors? And so it just depends. Most documents are going to have the provision that says that a co-owner can go after another co-owner, sue another co-owner to enforce the restrictions. And so sometimes, depending on the nature of the dispute, it may be appropriate that the association steps out and says, we're not going to get involved in this. This is a dispute between two co-owners. You've got to pursue this. If you feel strongly about it, we're not going to pursue it. Other times it's a situation where, I'll give you an example. I've got a case right now that it was the dog bite case that I just had to file a motion for summary disposition. A dog bit a neighbor on the hand, caused damage, and that individual has 4 children. And the question was, well, what happens if that dog then goes and bites another co-owner or the kids? And the association had knowledge of the fact that this dog was potentially dangerous or savage animal, which is what their documents prohibited. There are times that even if it may look like a dispute between neighbors, it's prudent for the association to get involved to avoid potential future liability down the line if something else happened with that dog, etc. Sometimes you'll just say, all right, you've got a noise dispute between 2 co-owners, nobody else hears it. That's a dispute that the 2 co-owners are going to have to resolve, and the association's not going to get involved in it. You could say call the police if there's a noise violation. Use a decibel meter and actually record what's going on and how loud it is, etc. When are the times that it's loud? Is it loud during the day, or is it loud at 2 a.m. in the morning? Things of that nature. So a lot of these are fact specific. So I don't give you a clear cut answer. I know hedging like all attorneys do, and that's terrible, and I hate doing it. Sorry. It really, though, is fact intensive as to whether the association should handle it or the co-owner do it themselves. And I'd rely on the advice of the attorney to tell you what's the more appropriate resolution.
Okay, that's helpful. Thank you.
You're welcome.
Hey, Joe, this is Don. Can you hear me?
Yeah, Don.
Question is, as a homeowner, 34 units, I guess I would say due to COVID, we haven't received a financial annual statement from 2019, nor have we received one for the first quarter or the second quarter. Any suggestions?
Yeah, so I mean, if there's no financial information that's been provided, you would contact your board and request a copy of it. Under the Nonprofit Corporation Act, that should be handed out. Some type of financial record should be made available to everybody. It can be done in person at a meeting, and usually it is. For most annual meetings, you'll come with a package available. If you can't do that, I'd recommend mailing a copy. If you can't do that, I'd recommend posting it on a website that can be accessed by the membership.
Yeah.
So
Okay. Our treasurer comes from a corporation where he doesn't think other people should have this, so
Hello, can you hear me?
he's reluctant to email it, which is terrible. We have not been able to have an annual meeting because of COVID. We can't even get, a church or typical community centers, restaurants, whatever, to host an annual meeting. I see no reason why he can't mail them out. I think I heard you say that earlier.
Well, I mean, here's the other thing. The question is, can you do an annual meeting by Zoom? And so you might be able to. I mean, I had my annual meeting by Zoom, and we provided financial information at our annual meeting by Zoom. If they're not doing that, then you can. I would put writing to the board requesting it.
No offense to the people on this conference call, myself included, but we have an older neighborhood. We have several people that don't even have email addresses. We have a couple of people that don't even have phones. So we've thought about Zoom. Matt has recommended that, but unable to do it. So yeah, I think we're not alone, I'm sure.
Yeah, I was just going to say we've had a lot of our clients reach out on that concern and say, listen, we could do it, but realistically, is it gonna happen because our community is an older community? Right. What I would recommend is still set it up and try to do it, and then if you don't meet quorum, then you can adjourn the meeting till a later date where hopefully you would be able to meet in person down the line, but at least make the attempt.
Okay, to have the meeting, but short of that, financial statement should be shared with the homeowners. It's their money, right?
Well, I mean, yeah, it should be, yes. It should be shared. If you haven't received it, then I would write a letter and ask for a copy of it. Okay. Or I'd have an attorney write that letter and ask for a copy of it.
Okay. Thank you very much, Joe. Appreciate it.
Hey, Joe, can you hear me?
Yeah.
This is Tammy from the Villages of Oscoda, and I had a question regarding pets. Our governing documents have breed restrictions, which include pit bulls. And when we try to enforce that, two things are happening. Either the homeowner presents us with a doctor slip saying it's an emotional support dog, or they provide us with a letter from the vet saying that it's actually a Chestershire thing. And when I look at the picture online, it looks just like a pit bull. Is all pit bulls this Chestershire breed? I mean, how do we defend on this? I mean, it's just, we're going nowhere.
Yeah, I would reach out. I don't know if our office represents you, but I would reach out to the attorney and get involved. I can tell you what we've done in the past is you can actually get a breed from a vet where it will show, mom and dad dog and go up in what the percentage is, even if it was a mixed breed at the mom level or the dad level or both, you can see what percentage the dog is of a certain breed. So we've been successful arguing that, okay, this dog, the lineage here shows that it's, 65, 75%, Doberman, pit bull, whatever the case may be. And then the other thing is with the emotional support animals, there's, like I said, that new case that just came down a month ago that gives you a little bit more teeth and to ask more questions about whether the documentation is actually sufficient or insufficient. And so from where we're sitting, even 2 months ago, had you asked me the question, I would tell you if somebody has a slip of paper saying they can have an emotional support animal, they probably have the right to have it. With this new opinion that came down, there's a little bit, we're leaning more towards, okay, you can start to do an investigation and actually try to figure this out, whether it's a legit emotional support animal or just a piece of paper to try to get around the deed restrictions. And so it's certainly something that it'd be worthwhile for you to talk to the attorney and get a legal opinion as to the particular issue or the more generic issue.
Okay, thank you.
No problem.
Hey, Joe, in our
Yeah.
association, we permit short-term rentals. Now, the board has been trying to overthrow that and change it, but they can't obtain a 65%, 2/3 approval to do that. Now they've come up with the thought of charging a fee, a service fee on those people who rent. When does that become punitive and when does that become reasonable?
Oh, just yet another question that I can't answer. It's
Sorry,
no. It's literally, asking one person what's reasonable compared to another person what's reasonable. Candidly, my answer to you, what's reasonable is what the judge says. That's the answer. I've had where I thought it was egregious what the other side was doing, and I've had judges say, nope, it's perfectly permissible. I've been on cases where I thought it was a little borderline, and then the judge rules in my favor. So the answer is, do they have the right under the documents to prohibit short-term rentals? What you've told me, the answer was no. Then the question is, do they have the right to impose those fines then or fees associated with it? I don't know. I'd have to look at the governing documents. The next thing is, have they created the appropriate scheme with rules and regulations and things of that nature that would allow for the fee schedule to take place? And was that appropriately approved? And usually it has to be disseminated to the community. Then I'd want to look at that as well. So in your circumstance, the analysis would be a tiered analysis to go through what do the documents allow for? Is this appropriate? The next step is, if it's not appropriate, is there a way to either amend the documents or do a rule and regulation? Is the rule and regulation, will it be effective? And if the rule and regulation is now in place, can you now charge a fee? Then the question is, how much can you charge for the fee? So there's that whole tier of analysis. And then I think your question is, they've already done all of that, and now they're to the point where, how do you know if it's punitive versus a reasonable fee? And the answer to that is, it depends on the judge.
If the documents do not mention a fee structure at all, and the board passes it because they decide it's the right thing to do, then I'm starting to wonder, just like you're pointing out, what's punitive and what's correct here.
In that circumstance, what I would ask Greg is, I'd ask you to reach out to your attorney and get an actual opinion letter on the topic. And the attorney will actually do the analysis, going through the documents and seeing what rights the association has or does not have.
Okay.
Joe, Bob Kolka, can you hear me?
Hey, Bob.
Oh, Joe? Yeah, good to see you. Good to hear you, and I enjoyed the webinar. I don't have any questions, but if any, to those of you who are still on, I've worked with Joe, probably five or 6 years, maybe more, and he's been a great law counselor. We've had a good number of legal issues to deal with, and Joe's always seen us through. And yeah, it's just good to know he's there when we need him. So if you're thinking about working with a law firm, I would recommend Hirzel Law to any of you that are still on. Great people to work with. Joe,
Thanks,
I'm going
Bob.
to leave it now because Barbara's held dinner, and we have a debate coming up that I think we want to see here shortly.
I'm jealous of the dinner.
Joe. Okay?
Jealous of the dinner. Have a good one, Bob.
All right. All the best.
You too.
This is Dan. Can I ask a question?
Sure, Dan.
This is on pets also. The question is, our pet policy is tied in with our township policy on the number of dogs that are available. And our policy in turn limits the height of a dog. And the question I have is, we have a person in our facility that has a therapy dog, which is greater than the height of our restriction. And that person was given a letter of approval to have that dog because it was a therapy dog, a dog that goes into the hospitals, nursing homes, and that. Did we compromise our policy by doing that?
All right, if I'm understanding, you cut off a little bit there for me, Dan. I don't know about everybody else. I'll try to, I'm going to repeat what I think you said and then tell me if I'm correct. You have a restriction on the height of the dog.
Correct.
In your governing documents. You have a situation where somebody has a therapy dog, which is greater than that height restriction.
Correct.
And is by allowing the therapy dog, would that be a violation of your documents? Is that the question?
Correct. We gave that person a letter saying they could bring it in. It came in after the seller did not just let the person purchasing it know that we had dog restrictions.
Okay, so there is a difference between a service animal, and if the therapy dog is a service animal versus an emotional support animal. But regardless, either way, if you have given permission based on even the fact that the dog is a service animal or the dog is an ESA, at that point in time, they are no longer considered pets at that point. They are considered an emotional support animal or, if you want to call it a service animal. They're no longer pets. So pet restrictions that would normally apply for pets, if you have those situations of an ESA, emotional support animal, that emotional support animal now it's perfectly permissible for you to allow that ESA to be in either your condominium or HOA, whatever it may be, if you've received the appropriate documentation or the board has determined that it's okay for this dog to be there. I will just caution you because the Bear Creek case, the one that I cited in my presentation, it also said that size and weight restrictions are inappropriate, are general. I think the case law said it was generally unreasonable. So if you have a size issue of the dog, how the height of the dog, I'd caution you that I don't know that would even be enforceable depending on the language in your documents. Based on the interpretation of the Bear Creek case, I think there's an argument to be made that the height of a dog has no bearing on whether it's aggressive, whether it bites, whether it barks all the time. Those are the things that the case kind of addresses is, no-nos. So something to think about, and I hope I answered your question.
Oh, you did perfectly. Thank you very much. Very good webinar. Thank you.
No problem. Thank you. All right. Any other questions? All right. It's almost been 2 hours. Hearing none. I'm going to check the chat real quick, see if there's anything I got to email the presentation. I can do that. Have you, Tammy's question, got that one? All right. I'm not seeing any further at this point, so I'm going to wrap it up. Thanks, everybody, for attending, and I hope you all have a good evening. Okay.
Thank you.
Thank you.